What is up? What is up, YouTube? Say it ain't so. Say it ain't so. This thing says another legal case. Hold up, y'all. Another legal case. This guy, I ran across his channel at Leonard Honor channel. He was on Leonard Honor channel. So shout out to him. And this brother is rolling now on the Umar stuff, man. Oh, let me go ahead. I'll hit that subscribe button, brother. I went on to subscribe to you, man. What is this called? The Jay White Podcast. Shout out to Jay White, baby. Give your thumbs up. Another legal case. Hit that subscribe button. Hit that bell. Hit that subscribe button. Hit that bell. Uncle Mike is gonna tell you what's
Grace
hype.
and peace, everybody. You saw the thumbnail. You saw the title. Today I'm gonna do something I haven't done in a while, which is we're gonna go over a court case. I put the ask out there earlier for anybody that has evidence that Umar Johnson has actually helped a child or helped a family or has supporters. And I said, hey, if you're a supporter, if you're a family, if you're a child that's been helped by Umar, why don't you come on in? Jump into the best live chat on the internet and let me know what has been your experience. Well, somebody, and I apologize to the brother, he sent me a link to a court case and he said this is evidence that Umar helped a child. Hey, hold on one second. This is editor Jason talking about what you're about to experience, which is your future, which is technically my past. Well, anyway, I did find the comment that the young blood left, and I'm going to actually leave it here so you can see what he said. And he gave the link, of course. I'll leave the link in the description of this court case where Umar Johnson allegedly helps a family deal with suing the school district because they determined that their child was disabled when they feel like the child shouldn't have been disabled. So let's check it out. After reading the court case,
Uncle Mike. Wait a minute. Uncle Mike read a little slow. How many individuals has he helped assist in such ways described in the case presented likely could be discovered? What the hell? I read all this and that's a bunch of nothing.
Determined that their child was disabled when they feel like the child shouldn't have been disabled.
Oh.
So let's check it out.
All right, let's check it out.
After reading the court case, he might need to go back and reevaluate what he said. Let's go. United States District Court of the Eastern District of Pennsylvania. Carol Durrell is the parent and education decision maker for SH, and it's versus the Lower Merion School District. Plaintiff SH and her mother, Carol Durrell, bring this action against the Lower Merion School District for violation of Section 5504 of the Rehabilitation Act. Okay. Before the court is the motion of the school district for summary judgment under Rule 56 of the Federal Rules of Civil Procedure. Now, very quickly, mom is suing the school district because something was done to her child. Okay, let's keep it going. Summary judgment is appropriate if the movement shows that there is no genuine dispute as to any material facts and the movement is entitled to judgment as a matter of law. And I am going to skip down because it explains where the laws are found and so forth. Jump down to the next paragraph. A dispute is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. Summary judgment is granted where there is insufficient record evidence for the reasonable jury to find for the plaintiff. So basically, you don't really have a lot of evidence. So therefore, let's go ahead and let the judge decide how this is going to shake out. There must be evidence on which the jury could reasonably find for the plaintiff. We view the facts and draw all inferences in favor of the non-moving party. Ruling on a motion for summary judgment, we may only rely on admissible evidence. The following facts are viewed in light most favorable to SH, and that's a student, and her mother as the non-moving parties. SH is a recent graduate of the Lower Merion High School. During first grade, SH was placed in Title I, a federally funded program for students who are not meeting benchmarks in reading comprehension. Title I is not considered special education and includes both children with disabilities and those without disabilities. The program provides students with 30 minutes of supplemental reading instruction daily. In her disposition testimony, SH's mother stated that although the school district characterized the program as an enrichment program designed to give children an extra boost, Title I is actually a remedial program, which has caused SH to miss a portion of her regular curriculum classes. Rather, she concedes that she never observed a Title I class. Instead, she based her opinion on conversations she had with children in her community who are currently enrolled in Title I. She received letters explaining the Title I program and consented to the SH's placement in the program. SH remained in Title I program through the fifth grade. At the end of fourth grade in 2004, SH's teacher told her mother that SH was struggling in math and reading. As a result, the school district conducted an educational evaluation of SH with her mother's consent. Santa Corinta, a psychologist employed by the school district, performed the evaluation. She tested SH with the Worcestershire Intelligence Scale for Children, number 4, which measures the child's verbal comprehension, perceptual reasoning, working memory, processing speed, and and full-scale intelligence quotient. She also used the Wilshire Individual Achievement Test, number 2, which assesses a student's achievement in 3 composite areas: reading, mathematics, and written language, and several subtest areas, including word reading, reading comprehension, pseudo-word decoding, numerical operations, math, reasoning, spelling, and written expression. Okay. To determine, they did a lot. They did a lot for this child. I ain't gonna lie. To determine whether SH had a specific learning disability, she made use of the predicted achievement discrepancy formula. Under the formula, the psychologist standardizes the student scores on these tests by comparison to a pool of other test takers. The psychologist then measures the difference between the student's standardized intelligence scores, typically the student's full-scale IQ, and his or her standardized achievement scores. Okay. The school district does not have a policy regarding what difference constitutes a discrepancy, which is sufficiently severe to demonstrate that the student has a specific learning disability. However, Dr. Joanna Wexler, a certified school psychologist employed by the school district, reports that the discrepancy of 10 to 14 points between the student's IQ and achievement scores may indicate a specific learning disability. Deborah Bgowski, the elementary supervisor for special education for the school district, testified in her deposition that psychologists in the school district generally use a 15-point discrepancy as the benchmark. Okay. So it could be between 10 to 15. I got you. The evaluation showed that SH had a full-scale IQ of 106, which was in the average range. The testing, however, showed a discrepancy of 14 points between SH's full-scale IQ and her reading composite score. There was also a discrepancy of 14 points between SH's IQ and her word reading subtest. Got it. Okay. And the 16-point discrepancy between SH's IQ and her reading comprehension subtest. Finally, a 16-point discrepancy was found between SH's IQ and one of her math subtests, numerical operations. She set forth in her evaluation SH's difficulties in performing various tasks during the testing and her below benchmark scores on 2 standardized tests, the Philadelphia System of School Assessments, and the degrees of reading power. She also relied on information provided by SH's teachers. She performed portions of the children's self-report, projective inventory, and concluded that SH had a good self-concept overall. He noted that SH had advised her that she did not want to receive special education services, although it was not mentioned in the evaluation. She stated that in her deposition, that she was aware at the time of the evaluation that there had been a serious tragedy in SH's family, specifically a deletion and self-deletion involving several of her relatives in 2002, that she consulted with SH's guidance counselor, Dr. Gloria Falcone, regarding the incident. She concluded that her evaluation of SH had specific learning disabilities in reading and math. Plaintiffs have several adverse circumstances of her report, according to their experts and the testimony of one school district employee. A specific learning disability requires a discrepancy of at least one standard deviation or 15 points. Their expert further opined that only composite scores, not subtests, please forgive me, should be used to compare a student's achievement with his or her IQ. Accordingly, SH did not meet the criteria for having a specific learning disability under their analysis. Plaintiffs further point out that she did not conduct a classroom evaluation or under regulations then in effect. However, as discussed above, SH's teacher shared her classroom observation of SH with her. Finally, plaintiffs' experts maintain that she failed to give sufficient weight to the possibility that SH was suffering from emotional disturbance at the time due to the serious tragedy that occurred in her family. After the evaluation, a team of school staff met with SH's mother to create an individual educational plan, IEP. The team recommended that SH receive 30 minutes of speech and language therapy per week and a daily 60-minute session of specialized reading and language arts and math instruction. SH mother received a notice of recommended placement summarizing the team's recommendation and a copy of her rights under the IDE. She then approved the placement of her daughter. Okay. During middle school, SH continued to receive special education services under the IEP approved by her mother. She was placed in instructional support lab, ISL, which is a resource room setting for students with learning disabilities to receive services such as extra assistance with homework and exams. This class caused SH to miss science class throughout middle school and 1 year of Spanish class. ISL grades are not counted in the student's grade point average. In SH's view, ISL is a waste of time that impeded her academic progress. Okay. So she missed science and Spanish. Goodness. Yeah. I mean, I can see where they're going with that. In 2007, the school district removed SH from special education services for language arts due to her progress in that subject. She continued to receive support in reading and writing. Thereafter, in September 2009, SH, reevaluated by Dr. Craig Cosden, another school district psychologist. Cosden concluded that SH continued to be eligible for special education and recommended that she attend ISL for 3 class periods every 4 days. Okay. Cosden also recommended that SH meet with a literacy and math specialist for 30 minutes every 4 days during her ISL time. Nonetheless, Cosden recommended that SH be removed from speech and language therapy because of her improved performance in this respect. I'm cooking along with you. I'm trending with you. The reevaluation report showed that SH full-scale IQ was 86. SH tested as average on her reading composite scores and all reading subtests except for reading comprehension, which was below average. She was found to be below average or low average in achievement in all math scores and average in written language. According to plaintiffs' experts, Cosden failed to take into account whether SH was again suffering from an emotional disturbance due to the remarriage of SH's mother during the 2004-2005 school year and the passing of a close friend of hers in 2006. They also opined that Cosden failed to consider indicators of SH's improvement in academic performance after 2004 evaluation, including her scores on several classroom assessments, the Pennsylvania system of school assessments, and her report cards. In May 2009, Cosden attended a meeting with SH's mother and her counsel. During that meeting, plaintiffs requested a copy of the testing protocols used by Cosden in the 2009 reevaluation. The protocols were described by Cosden as the paperwork itself that tests are printed on or answers are recorded on, which are published by the test manufacturer. Cosden informed the family that the testing protocols had been destroyed. This was untrue. Cosden admits that he misled the family because he did not want to provide the protocols to persons who have no ability to be able to process the understanding of the information contained on them. He also stated that he did not provide them to the plaintiffs because of copyright infringement policies and ethical standards. Cosden later provided the protocols pursuant to a subpoena. The protocols are not part of the record before the court, and thus their exact contents are unknown. Why did y'all say all that if none of that was useful? Okay. In January 2010, the plaintiffs had SH independently evaluated by a certified school psychologist, Dr. Umar Johnson.
Finally, okay, we about to get to the juice, the meat and the bones, y'all. It's been 14 minutes. You should have summarized some of that stuff, bruh. But it's all good. It's all gravy. So we want to see exactly what is going on. Here we go.
He found the SH full scale IQ was 100. He placed her in the average to superior range for all areas except for reading comprehension and fluency, in which SH was below average range. He found that any discrepancy between her intelligence and achievement was too small to support the existence of a specific learning disability. He then concluded the central finding of the independent educational evaluation, the TEE, is that SH appears to have never met the criteria for a diagnosis of specific learning disabilities, SLD. At the time of initial diagnosis during the fifth grade, SH's reading and math standard scores were within the average range. In addition, during the time, SH was still grieving the loss of several family members to a violent tragedy, which could have been at least partially accounted for any skill delays perceived by the evaluating psychologist at that time. This determination is supported by standardized test scores and report cards during the fourth grade and beyond, which show that SH was progressing adequately. Okay, shout out to you, Umar. Afterwards, in April 2010, Cosden reevaluated SH. He wrote that SH's mother had requested that SH continue to receive speech and language services. SH's mother denied making this request. Cosden concluded that SH remained a student with learning disabilities throughout SH, although SH no longer required special education services. He recommended that she be moved out of all special education programs due to her progress in school. Okay. In April 2010, at the request of her mother, SH was removed from all special education programs. She spent the remainder of her last 2 years of high school in regular education classes. According to the plaintiff, SH receipt of special education services damaged her self-confidence and academic progress. It also prevented her from participating in certain regular curriculum classes, including science and 1 year of foreign language during middle school and a higher level during high school. Her expert calculates her damages as $127,010, which includes 2 additional years of college tuition, 50 hours of psychotherapy, and 600 hours of tutoring. Wow, man. Okay, they said 2 additional years of college. So because of this, she's behind 2 years. She's going to be behind 2 years in college, 50 hours of psychotherapy, and 600 hours of tutoring. It's crazy. As of the date of her disposition in February 14th, 2012, SH had been accepted to West Virginia Hudsontown University Cambria College, and Newman University. SH had also applied for Westchester University and Temple University, but as of that time, she had not received any decision on her admission to these schools. The Rehabilitation Act provides no otherwise qualified individual with a disability in the United States shall solely be by reason of his or her disability be excluded from the participation in, be denied the benefit of, or the subjected to discrimination under any program or activity receiving federal financial assistance. The ADA similarly states no qualified individual with a disability shall by reason of such disability be excluded from participation in or by be denied the benefit of their services, programs, or activities of a public entity or be subjected to discrimination by any entity. The standards governing SH's Rehabilitation Act and ADA claims are the same. All right, we already said that. To prevail on these claims, plaintiffs must demonstrate that SH1 has a disability. Okay. 2, was otherwise qualified to participate in school programs. And 3, was denied the benefit of the program or was otherwise subject to discrimination because of her disability. The definition of disability under both the Rehabilitation Act and the ADA includes not only an individual who is actually disabled, but also anyone who is regarded as having a disability. Okay, we got that. There's no dispute that SH was regarded as disabled by the school district and that she was otherwise qualified to participate in the school activities. Thus, the sole issue before us is whether plaintiffs have put forth sufficient evidence to raise a genuine dispute of material fact that SH was denied the benefits of a school program or subject to discrimination on the basis of her perceived disability. Plaintiffs assert that the school district discriminated against SH by placing her in Title I classes, misidentifying her as a student with disabilities, excluding her from regular education classes, and 4, placing her in ISL classes, which are not counted towards a student's grade point average. The school district maintains that it is entitled to summary judgment on SH's claim for compensatory damages because plaintiffs have failed to adduce any evidence that it intentionally discriminated against SH. Plaintiffs asserted that she need not prove that the school district's discrimination was intentional in order to recover under the Rehabilitation Act and the ADA. In support, they cite their court appeals decision in Ringwood Board of Education versus NE. And since Ringwood was decided, the Supreme Court has made clear that the remedies available under ADA and the Rehabilitation Act are coexistent with the remedies available in a private cause of action brought under Title IV, actually Title VI of the Civil Rights Act of 1964. Barnes and Gorman, under Title VI, a plaintiff may not recover compensatory damages absent proof of intentional discrimination. Okay, we know that. In light of these decisions, Ridgewood has been superseded. Not surprisingly, we note that all courts of appeals to address the issue since, and the majority of district courts within the Third Circuit have reached the conclusion enunciated by the Supreme Court. These courts have required some evidence of intent, such as bad faith, gross misjudgment, or deliberate indifference, to sustain a claim of compensatory damage under these statutes. And we already have that already. We are not aware, and neither party has cited a case in which a plaintiff student has alleged that he or she was incorrectly identified as disabled and discriminated against on that basis. In addition, in violation of the ADA and Rehabilitation Act, however, there are several decisions in which plaintiffs have alleged the inverse, that the student was wrongly classified as non-disabled and excluded from special education services on that basis. In Mouse versus Wappinger Central School District, a school district refused to classify a student with attention deficit disorder, anxiety, and Asperger's syndrome as disabled under the IDE because she was performing at average or above average level of the students. Okay, we got that. Student and parents subsequently brought claims against the school district for violation of the IDEA and ADA and Rehabilitation Act in support of their ADA and Rehabilitation Act claims. The plaintiff stated there are tribal issues of fact precluding a grant of summary judgment in the Section 504 and Title II claims, which with respect to the 2003-2004 school year. The defendants knew KM, I guess that's the student, was disabled, not just ADHD, but developmentally and socially disadvantaged. This put her in an obviously inferior position to her more able peers and left her vulnerable to social isolation, anxiety, and depression. Her mother's efforts to bring KM's problems to the defendant's attention was to no avail. Okay, we got that. Let's finish this up. The district court granted summary judgment in the school district's favor on plaintiff's ADA and Rehabilitation Act claims. It reasoned that the claim that the school district misclassified a student without any evidence of bad faith or gross misjudgment cannot survive summary judgment under these statutes. The court further stated that a school district is not required to provide students with disabilities with potential maximizing educations, only reasonable accommodations that give those students the same access to the benefits of the public education as all other students. That makes sense. Similarly, in Sellers and the School Board of Manassas, a student and his parents brought claim under the ADA and Rehabilitation Act against the school district for failure to identify him as disabled. So what they're saying here is not usually the other way around, where they've determined that a student is disabled, only to later find out that maybe they should not have made him disabled. They're saying that there's no case law for that. The only cases that are out there are kids that were disabled and were not given the proper services. That makes sense. The district court granted the school district motion to dismiss the plaintiff's claim for failure to state a claim under Rule 12. The Court of Appeals for the Fourth Circuit affirmed on the ground that the plaintiffs had failed to state that the school district intentionally discriminated against them. In doing so, it stated the reference in the Rehabilitation Act to discrimination must require, we think, something more than an incorrect evaluation or substantively faulty individualized education plan in order for liability to exist. Experts often disagree on what the special needs of a handicapped child are, and the educational placement of such children is often necessarily an arguable matter that a court may, after hearing evidence and argument, come to a conclusion that an incorrect evaluation has been made is not necessarily the same thing as holding that a handicapped child has been discriminated against solely by reason of his or her handicap. If I'm understanding that correctly, all they're saying is, look, man, all of us been trying our best to figure this out. It's not always a cut and dry. It's not always a slam dunk. Sometimes we mess it up, but we don't do it intentionally. And you have to show that they've done it intentionally, not just in good faith. They just made a mistake. So that's how I'm understanding it. But let me know what you think down in the comments. Let's finish this up. To require less than intentional discrimination would be to invite claims of educational malpractice. That's hilarious. I love that term. All right, let's go. Such tort claims for monetary damages stemming from a wrongful identification of a student as disabled have been uniformly rejected. Wow, okay. While plaintiffs contend that intent to discriminate is not necessary, they attempt to set forth evidence of discriminatory intent. How do you do that? If you say they didn't have intent, while plaintiffs contend that intent to discriminate is not necessary, they attempt to set forth evidence of discriminatory intent. That's interesting. Assuming that plaintiffs must establish the school district's intent to discriminate, they point out that psychologists from the school district concede that they have a great amount of discretion when conducting evaluations. Plaintiffs reason that this discretion gave the school psychologist the opportunity to discriminate against SH. Plaintiffs also reference as evidence the school district's intentional discrimination that in the 2010 reevaluation of SH by Cosden omitted a mention of the fact that the educational evaluator engaged by plaintiffs Abdullah Johnson had concluded that the identification of SH as disabled was an error. So basically, they're saying that, hey, you didn't mention that Umar Johnson, Abdullah Johnson, said that what you all did was wrong in your report. I guess they didn't add a conflicting voice to what it was that they were submitting. Okay, I got you. The plaintiffs further assert that Cosden intentionally misrepresented the wishes of SH's mother regarding the continuation of speech and language services for SH. In response, Cosden explains that he did not reference Abdullah Johnson's conclusion because it wasn't relevant to the question at hand, which was, does she qualify for services now? Does she okay. So, and he's just saying, hey, what Umar was talking about back then was not relevant to what we're talking about at this moment right now. And as discussed above, although Cosden concluded in his 2010 reevaluation that SH remained a student with disability, he recommended that she no longer receive special education services as additional support of the school district's intent to discriminate against SH. Plaintiffs emphasized that Cosden purposely misled them into believing that the testing protocols used to evaluate SH had been destroyed. As we noted above, plaintiffs have not made these protocols a part of the record, and therefore the court is unable to make any judgment as to their significance. Finally, as evidence of intentional discrimination, plaintiffs rely on deposition and testimony of SH's mother that she relied on the judgment of the school district employees and was misled by them. She states that the school district mischaracterized the nature of the Title I program and our opportunities for overriding school teacher recommendations for course selections. You want to be involved? I got you. Plaintiffs also cite the school district policy, which provides that ISL does not count toward student grade point average, and then draw an inference that this policy was intentionally adopted to limit the ability of SH to obtain a high grade point average as her peers in regular education. How do you prove that, Tom, man? You can say it, and I can actually see what they're saying. I just don't know if I agree. How do you make that claim, though? None of this evidence that can reasonably be viewed as intentional discrimination against SH because of the school district regarded her as disabled. None of this is evidence that can reasonably be viewed as intentionally discrimination against SH because the school district regarded her as disabled. Instead, the record demonstrates that the letters and paperwork provided to SH's mother regarding Title I and course selection contain the same information provided to any other parent in the school district. SH's parent consented to all of SH's placement, even at times requested additional services for SH. Similarly, there is no evidence that the policy regarding grade point averages and ISL classes was adopted with SH in mind. Instead, this policy applies to all students in ISL. In our view, plaintiffs have not produced any evidence of intentionally discriminating, which raises a trial issue of fact. We agree that plaintiffs has raised a genuine dispute of material fact regarding whether the school district was incorrect when it classified SH as having special learning specific learning disabilities in math and reading. Their experts have pointed to various defects in an initial evaluation and reevaluation of SH. Plaintiffs have also produced at least some evidence that school staff may have been incooperative with plaintiffs' initial attempts to remove SH from special education services, and in one instance was not truthful with plaintiffs about the existence of certain protocols. At most, these evidence raises factual issues regarding whether the school district acted unreasonably in its treatment of SH and thus engaged in additional educational malpractice. The ADA and Rehabilitation Acts, however, are not educational malpractice statutes. While we find any misidentification of SH unfortunate, plaintiffs have not come forward with any evidence which would allow a reasonable jury to find that the school district intentionally discriminated against SH when it regarded her as disabled. Accordingly, the motion of school district for summary judgment will be granted. All right. That is it. That is an example. I don't think Umar helped. I don't know. Umar tried. Let me be honest. Umar does try. He does evaluate the student, but they didn't prevail. It didn't prevail at all. So I'm not certain why this person gave me this as if this is a slam dunk that Umar Johnson did a great job. He did try to help. No question there. Not going to take anything away from that, but that was it. Let me know what you think. Maybe I'm being a little bit too pesky. Maybe I'm being a little bit too nitpicky. Do you think that this is evidence that Umar helped this young girl? Or do you think that is not? What do you think? Down in the comments below, let me know. I really do appreciate it. Thank you so much for rocking with us. And until next time, everybody, grace and peace. Thank you so much for tuning in to another episode of the Jay Witt Podcast.
Jay Witt Podcast, man. Hey, I'm just gonna be honest with you, man. I was over this joint almost falling asleep. But did he help? Nope. Anybody could have did what he did. Just be more get a second opinion, basically. Get a second opinion, man. And the more you pay for the second opinion, the more they're gonna be on your side. Come on, man, y'all gotta learn how the world works. And the thing that tripped me out is, I think Dr. Umar probably did as least as possible because it wasn't that much money involved. I wonder how much the parents paid Dr. Umar to do these NAICS evaluations and all this type of stuff. So I would love to know. It seems like to me, all the stuff that I covered, Dr. Umar does things for money and getting with the parent, getting in bed with the parent. So if it ain't no money involved and he ain't getting in the bed with the parent, I wonder what the conclusion would be then. Y'all take it light, take it slow. Tell him Uncle Mike told you so. Peace out.